The Inheritance Provision for Family and Dependants Act 1975 is an act of Parliament which allows certain categories of people to make a claim for what's known as reasonable financial provision from a deceased person's estate. That can, for instance, be where the deceased failed to make any or very little provision for another person in their will, or where they simply didn't leave a will, in which case the strict legal rules which apply may not necessarily have provided for that person. What's reasonable financial provision really depends on the particular case as well as on the individual circumstances of the parties. The factors which the court considers are set out in Section 3 of the Act. These are the financial resources and needs which any person claiming or any beneficiary has or is likely to have in the foreseeable future, any obligations and responsibilities which the deceased owe to any person claiming under the Act or towards any beneficiary, the size and nature of the net estate, any physical or mental disability of any of the parties, and any other matter including the conduct of any party which, in the circumstances of the case, the court might consider relevant. With the exception of spouses and civil partners, who are entitled to a higher standard of financial provision under the Act, for all other eligible parties, the purpose of the Act is to provide them with an amount sufficient for their maintenance, which is again determined on a case-by-case basis. There's a strict time limit of 6 months from the date of the grant in the estate to bring such a claim. The grant is a document which provides a person known as the executor or administrator with authority to collect in and administer the estate. Claims can, however, be brought outside of that time limit in exceptional circumstances, but the key is always to act quickly. Crucially, a claim under the Inheritance Act isn't a claim challenging the validity of the will, which is a separate claim altogether. Instead, it's a claim challenging the amount left to a person, whether under a will or otherwise.